Hi everyone, I'm Ben Holt. I'm a partner in the commercial litigation team at VWV. And probably about half of what I do is general commercial disputes, and the other half is what I rather grandly call reputation management. And this includes things like defamation and internet takedowns, but certainly recently, predominantly data breach and privacy type claims. I head up the information law team at VWV. So I'm heavily involved in advising institutions and businesses on data breach and other critical incidents, from assisting with comms and notifications when a breach first arises, right the way through to defending any claims that are brought against the institution as a result. Sarah Perry is an associate in my team and regularly works on this kind of claim. HE institutions, like lots of other organisations, inevitably hold and process huge amounts of personal data. At some point, it's almost inevitable that you'll find yourselves having to deal with a data breach. And that can range from a one-off accidental breach, such as mistakenly sending an email to the wrong person, right the way through to falling victim to a malicious hack or cybersecurity incident that compromises your entire database of servers. We're seeing an increasing number of claims being brought against clients for data breaches arising from these kind of incidents. As you may be aware, there's firms and solicitors specifically focusing on these types of claims, and they often advertise for claimants in the wake of high-profile, widespread data breaches, such as the fairly recent British Airways breach. In fact, on that case, there was an interesting ruling by the court earlier this month, and this really puts things into perspective. Essentially, the lawyers were told that they couldn't recover their advertising costs back from British Airways. An interesting report from the Law Society Gazette, it said London firm PGMB had applied to be able to recover the costs of a media advertising campaign for its litigation over a massive data loss. The court heard that in advertising proceedings to potential new additions, the claimant's firm had incurred £443,000 thus far, and intended to incur another £557,000 from what was described as a very substantial media publicity. Yeah, that's right. The lawyers were looking to spend £1 million advertising the claim. And some people have preconceived ideas that lawyers are money grabbers, but clearly these sorts of claims need to be taken very seriously. There's been a number of data breaches reported in the HE sector too, and these present their own unique set of issues. Could we get the first slide, please? So today we thought we'd run you through what to do if a data breach arises in your institution. We'll take a look at the type of claims that can be brought for data breaches. We'll consider how much these claims can be worth and take a look at a few examples. We'll take a quick look at ICO fines, and then we'll finish off with some top tips for you to take away. Next slide, please.
So what should you do if you become aware of a breach? The first thing is not to panic. Data breaches are often very fast moving, so it's important that you keep calm. Depending on the nature of the incident, it's possible that the press would already be aware of it. If you're approached by the press or media for comment, don't be pressured into making one on the spot, even if you're only given a very short timescale for responding. It's almost never a good idea to simply refuse to comment though, as this could be misinterpreted. Instead, take the time to prepare a statement that's short and factually accurate. It's often a good idea to do this with help from PR advisors. These can be your own internal ones if you have them, but for particularly tricky incidents, it can be helpful to engage external crisis communications advisors who specialise in this kind of PR. It can involve quite a different skill set to normal PR, and there's often the benefit of a wider perspective by involving someone from outside the organisation. Be careful about stating something as a fact if you don't yet know for certain that it's true. For example, we're often asked to review draft statements from a legal perspective, where the organisation is keen to put something out that confidently says no sensitive personal data has been compromised, or that the breach is only limited to a certain number or type of information. However, at a very early stage, when your investigations will probably still be ongoing, it's often impossible for you to know that for certain. Whilst it may be understandable to want to try and do some damage control as soon as you can, it will be much more damaging for you to say one thing and have to try and row back from it later if it turns out to be wrong, than it would to put out a cautious, measured statement. There have also been instances where well-intentioned early statements have been made that don't provide enough information. For instance, that only a small percentage of a group have been affected, or that financial information hasn't been compromised. The reputational damage can be done by such initial statements, even where clarification statements are issued shortly after. This is worth bearing in mind because it's often how an institution deals with a data breach rather than the data breach itself that can attract the widespread negative attention. This is another reason why it can make sense to engage external crisis PR specialists at an early stage. Now, it's possible, of course, that a breach may have occurred as a result of a particular employee's actions. In those cases, you'll owe the employee a duty of care as their employer, and you'll obviously want to support them in an appropriate way. But you should be careful about making early statements that directly or indirectly identify the individual, either positively or negatively. Again, whilst you're making statements that openly support the individual, in case your investigation uncovers information that means you need to row back on that, or commence disciplinary proceedings against the employee. And this, of course, can be quite difficult, particularly when the employee in question is senior. The employee shouldn't be directly involved with the university's decision-making in connection with the incident or the instructing of lawyers to avoid creating the perception of any conflict of interest. And the employee may want to obtain legal advice of their own as well. Next up on our slide, we have coordinate. Now, a lot of this may appear to be simply common sense. However, when you're at the centre of the storm, it can be really tricky to take that breath and step back, and the simple things are often key. It's so important to make sure that everyone in the organisation is on message and that there's one consistent narrative that's being put out there which is accurate and up to date. Otherwise, you run the risk of conflicting or inconsistent statements being seized upon by the press or by the public. Ensure only designated appropriate individuals within the institution are tasked with dealing with any comms and inquiries, and make sure all other staff know where to send any inquiries if they're approached by anyone directly. It's also sensible to make sure that you have the key contact details for decision makers in your organisation readily to hand, so that you're not rushing around or struggling to get hold of anyone when you need them urgently. Ideally, you want at least 2 people tasked with dealing with aspects of a crisis, so that if one of them is off sick or on holiday when something actually arises, you're not held up in any way. For instance, we've certainly seen this with senior IT managers. Don't let them both be out of contact at the same time.
For communication, you may be under an obligation to inform the Information Commissioner's Office of the incident, as well as any other regulators such as the Office for Students. When you first become aware of a breach, it's of course likely that you'll not know the full detail. The ICO requires that notifiable breaches, and that's not all breaches, but notifiable breaches, are reported to them within 72 hours of you becoming aware of them. It may, however, be appropriate to make a short initial notification to the ICO and follow up later when you have more details. And you should think strategically about what's included in your notifications, whilst obviously complying with your legal and regulatory obligations. And we'll talk later on about the fines that the ICO can impose. And you should bear in mind that the ICO will also look closely at what you do once you become aware of the breach in assessing that fine. Even if something does not seem to be notifiable at the outset, you should keep this under careful review and bear in mind that it's generally better for regulators to be notified of incidents by you rather than them having to find out about an incident from the press or third parties. And certain regulators can take a very dim view of this. It's generally the case that a serious incident report to your regulator should be considered where something has the potential to damage your institution's reputation as well. Depending on the nature of the breach, the police may also need to be notified. This should clearly be done at a very early stage, and you should make sure that you liaise with the police before you publish any comms of your own in order to inadvertently prejudice any criminal investigation. Subject to that, you'll want to make sure that staff, students and other key stakeholders are kept up to date if and as appropriate. Clearly, your communications will need to be tailored to the audience, but a key is usually to ensure that they're all consistent. You should also think carefully about whether, when and how individuals should be notified. They don't automatically need to be told if the risk of harm to them is low, but this should obviously be kept under very careful review and needs to be balanced against the risk of someone finding out by other means. And of course, your wider legal and regulatory obligations, particularly if, for example, the individuals involved are students or staff members. Insurance. Check whether you need to notify your insurers. This is particularly important if the matter is something that could result in a claim being brought against your institution. As we'll discuss later, the damages awarded in data breach claims are often, in day-to-day cases, not that large per claimant. A lot of the time, the real issue is around legal costs, which can quickly become out of all proportion to the issues at hand. Insurance is therefore absolutely vital to dealing with the claim, not just for the potential damages, but to protect against liability for your opponent's costs as well as your own. You'll usually be required to let your insurers know about circumstances which could give rise to a claim, and failure to do so could mean that any costs you incur prior to notification are not recoverable, or even that your cover becomes void. We'd suggest checking your policies now so that you know exactly who you need to contact and how if an incident arises. And if you have one, your broker may be able to assist you with this. Another reason for bearing this in mind is that you may actually have cover for other things that may be invaluable in these scenarios. We certainly have some clients whose policies include cybersecurity cover or PR and crisis communications cover. So insurance leads us quite nicely onto claims now. So let's move on to that. Next slide, please.
So after navigating your way through the incident itself, it's possible that once the dust has settled, you're faced with claims by individuals who've been affected by the breach, and this of course raises issues of its own. With the introduction of GDPR back in 2018, the issue of data protection and privacy is at the forefront of most people's minds, and we've certainly seen a marked increase in the number of claims being threatened or brought against organisations in recent years, for even quite minor or trivial data breaches. As you can see on the slide, these claims are usually based on allegations of breach of the Data Protection Act, misuse of private information, human rights in breach of privacy, and breach of confidence. Claimants will generally chuck in the kitchen sink and claim on pretty much all grounds, but briefly taking each of these in turn. A person who suffered damage as a result of a breach of the Data Protection Act can claim compensation from the data controller or processor, as well as making a complaint of their own to the ICO. For data breach claims, a key breach relates to a failure to ensure that personal data is protected against unauthorised or unlawful processing, and against accidental loss, destruction, or damage. We've also seen an increase in claims relating to a loss of control of data, sometimes where there isn't really any other obvious ground to hang the claim on. Next is misuse of private information. And in assessing a claim for this kind, the court will consider whether the information was obviously private. So essentially, whether the claimant had a reasonable expectation of privacy in respect to that information. This will take into account the specific facts of the case, including, amongst other things, the nature and purpose of the intrusion and the effect on the claimant. If information is private, the court will consider whether the disclosure of the information would give substantial offence to a person of ordinary sensibilities placed in similar circumstances to the claimant. Next is the Human Rights Act. Under that Act, of course, everyone has the right to privacy, and no public authority can interfere with that right, subject, of course, to any competing rights like freedom of expression. As a public authority, the court must take into account convention rights, even if all the parties before it are private. In claims against non-state bodies, there must be an existing cause of action, such as breach of confidence or misuse of private information, before human rights can be considered, but in practice, that's an easy hurdle to overcome. Finally then, a claim for breach of confidence can be brought in circumstances where the information in question is confidential, was provided in such a way that imposes an obligation of confidence, and was disclosed in such a way that is detrimental to the individual in question. The claimant will need to show that the private information was disclosed in breach of a clear duty of confidence. It's therefore slightly different to a claim for misuse of private information, as that can occur even where there is no pre-existing relationship of confidence between the parties. And not all confidential information falls within data protection laws. These are all slightly different legal principles, but fundamentally the result is usually largely the same. Now, at this point, we wanted to spend a bit of time talking about vicarious liability. There's been some really important case law on the extent to which employers can be vicariously liable for data breaches committed by employees. The most important of these is probably the Morrisons decision, handed down by the Supreme Court last year, which you may have heard about. It's a really important case because it sets clear limits on the scope of vicarious liability. So we wanted to run through the facts of this one with you now. Next slide, please.
So the Morrisons case relates to the malicious actions of a chap called Andrew Skelton, who was an internal auditor for Morrisons. He also operated a small business selling a slimming drug through eBay, and occasionally he'd send out the packages through Morrisons' post room, having fully paid for the postage himself. One day, one of the packages came open in the post room, and white powder spilled out, causing chaos and not an insignificant amount of investigation as to what it was. Skelton was given a verbal warning. He then got the hump with Morrisons and planned his revenge. In his role as an auditor, he had access to payroll data, which included personal and banking details, of around 120,000 Morrisons employees. He took a copy of most of that data, put it online, and sent it to newspapers. He also used a false email address, trying to frame one of his colleagues in the process. He also timed the disclosure to coincide with the publication of Morrisons' annual financial results in order to cause maximum damage. Skelton was sentenced to 8 years in prison for this unlawful and criminal disclosure. And then just over 9,000 current and former employees who were impacted by the breach then took legal action against Morrisons, seeking damages for distress caused by the disclosure of their data through breach of Data Protection Act, breach of confidence, and misuse of private information. They claimed, amongst other things, that Morrisons was vicariously liable as Skelton's employer. The Supreme Court held that Morrisons was not vicariously liable. It found that Skelton's disclosure was not in the field of activities of his employment and that his intention to harm Morrisons was relevant. The court drew a distinction between cases where an employee is engaged misguidedly in furthering his employer's business and cases where an employee is engaged solely in pursuing his own interests. And here, Skelton was clearly pursuing his own interests, where he wrongfully disclosed the payroll data, and so his conduct wasn't sufficiently connected with acts that he was authorised to do for there to be any vicarious liability. Now, this obviously should provide some comfort to HE institutions. However, it's important to note that the court didn't completely exclude the possibility of employers being vicariously liable for employees' statutory data breaches. Under different circumstances, an organisation can still be vicariously liable for a data breach by an employee, as it can for other actions. An extreme example of this is not too long ago either, and also involves vicarious liability in Morrisons. Case of Mohammed and Morrisons. A customer who was on his way to a community event had got into a Morrisons petrol station and asked an employee where he could print some documents from a USB stick. The employee responded with foul, racist and threatening language and told the customer to leave. The customer left, and then the employee followed him into the forecourt and subjected him to a serious physical attack. The customer brought a claim against Morrisons, and the court had to consider whether Morrisons was vicariously liable for that employee's actions. And in that case, it was held that Morrisons was vicariously liable. That's because it was the employee's job to attend to customers and to respond to their queries. His conduct was obviously completely inexcusable, but it was nonetheless within his field of activities assigned to him and was in connection with the business in which he was employed. Although, of course, that's not a data breach case, the principle of vicarious liability applies to all claims, and this is a somewhat extreme example of how vicarious liability can apply. So let's take a hypothetical example in a HE context to consider this further. Let's say an academic employed by the university accidentally publishes personal data online that they're using as part of an academic study in work for the university. The personal data remains online for some time before the error is discovered, and then it's taken down. Now, in those circumstances, there's arguably a sufficient connection with the employee's unlawful actions, the inadvertent data breach, and their role at the university as an academic. in that case, the university could well be vicariously liable for the employee's unlawful actions. Contrasting that with another hypothetical example, let's say the academics become disgruntled with the university because the funding for their work has been cut and they want revenge, and they decide to post personal data from their academic study on Twitter and send copies to the press in the attempt to create bad publicity for the university. Well, that's obviously more akin to the first Morrisons case, where Mr. Skelton had been out for revenge against Morrisons. I think it's decent argument in that circumstance that the university wouldn't be vicariously liable for the academics' actions, but it's never clear cut, and it will obviously depend upon the exact circumstance of the case. This is one of the many reasons why it's so important to ensure that your staff have relevant data protection training and aware of the policies and procedures that your institution has in place. It's also just worth noting, and there's probably not too much to be drawn from this, but it's an interesting exercise, just looking at the Morrisons case, that there was 9,000 claimants out of about 120,000 potential. So that's about 7.5%. Now, I suspect quite a lot of them didn't fancy bringing a claim against their employer, and probably quite a lot of the others couldn't be bothered. And frankly, who could blame them? I do feel, I mean, we don't really act for claimants on these matters. It's almost entirely defendants. And a lot of the claims seem opportunistic nonsense with no real impact on the person. It's just an attempt to try and get some money. I mean, surely there can't really be any substantive loss in the name and address being leaked on the whole in most cases. And arguably, not really even if your salary, if people know what job you're in. You're going to have a rough idea as to how much somebody who works on a till in Morrisons is going to get, probably. But if you apply this sort of fag packet formula to breach at your institution, what if even just one faculty's data was breached? How many students would that involve? I'd like to think, and certainly we have seen that for some universities, students and alumni have a loyalty to their institution and wouldn't want to bring a claim unless they were really seriously affected. That might be wishful thinking, but even if it was 7.5%, that's still a lot of claims. Even if they aren't worth much individually, if you times that by several hundred or potentially thousand, it suddenly becomes quite daunting. And that's without taking into account anyone for whom you're holding particularly sensitive data. Next slide, please.
So if you receive a claim or claims from a data breach, one of your first questions is likely to be how much of these claims, how much can these kinds of claims be worth? And unfortunately, I've got a typical lawyer's answer here because it depends. The starting point is that damages are compensatory in nature. So the question is, how much loss has actually been suffered? The difficulty at the moment is that this is an area of law that's constantly developing. And when it comes to advising on how much these claims are likely to be worth, the vast majority of the case law relates to the more high profile and serious data and privacy breaches. One of the most extreme examples of this is the phone hacking litigation, which you've all probably heard of. These cases, of course, arose from phone hacking and use of private investigators by newspapers against individuals, some famous and some not, that often resulted in stories being published about them. Many of the affected individuals brought claims against the papers, and one of these cases is known as Gulati. Out of interest, the lead celebrity here, Gulati, is Shobna Gulati, who you may recall as Sunita in Coronation Street and Anita in Dinladies. The damages in Gulati range from around £72,000 to as much as £260,000. Prior to the phone hacking litigation, the highest award in a claim of this kind was £60,000, which was an award made to Max Mosley following the publication of extremely personal details about his personal life. However, the Gulati award was very fact-specific, and the high amount was partly down to it reflecting the fact that there had been frequent and sustained instances of phone hacking over a long period. Claimants' voicemails were even being hacked as much as twice a day over a period of years. So although some of the awards in Gulati were exceptionally high, the court did give some general guidance on what should be taken into account when awarding damages, and some of these are set out on the slide. So the first of these is the type of information disclosed. Although this isn't a defining factor, disclosure of information that is more likely to be expected to be private will attract a higher award in damages. This might include things like medical information or bank details. In each case, the precise nature and significance of the information that is disclosed will be relevant. Next is the nature and extent of the disclosure. So as you might expect, deliberate and repeated or widespread publication of the data is likely to be viewed as more serious than a limited and inadvertent disclosure. Finally, there's the consequence of the disclosure and the effect on the individual victim. Disclosure leads to temporary embarrassment will be treated differently to a disclosure that has a long-lasting or life-changing effect on the individual. To a certain extent, this will depend on the nature of the individual affected and their specific circumstances. And the courts have also suggested that the amount of damages awarded for distress in these kinds of claims should be in line with damages awarded in personal injury claims. Next slide, please. So let's look at some examples to see how this is working in practice. We've got some cases on the slide here, and although some of these predate the GDPR, the position is still largely the same. Some of these cases involve newspapers and high-profile publicised breaches, but we also wanted to include some reported examples of more low-level and accidental breaches too. As we go through each case, just keep in mind the factors that we listed previously, especially the type of information disclosed and the nature and extent of the disclosure. So the first one is Ali and Aslam and Channel 5. This case involved the eviction of the claimants from their home being filmed for the TV programme Can't Pay, We'll Take It Away. The programme was brought to around 9.65 million viewers. The court accepted that the programme involved the disclosure of personal information about the claimants, their eviction, which was fairly sensitive, and awarded £10,000 in damages to each claimant. The awards would have been higher, but footage was also posted online by someone else, and that needed to be reflected in the damages that the defendant was ordered to pay. The next case is ZXC and Bloomberg. Z, the claimant, was an executive of the company that was being investigated by a UK law enforcement body for corruption. Bloomberg published an article which contained confidential information taken from a request for information sent by the UK investigator to foreign authorities, seeking information in relation to Z and other executives at the company. No charges were ever brought against Z as part of that investigation, and he was never even arrested. Z then brought a claim against Bloomberg. And the court held that Z had a reasonable expectation of privacy in an investigation up to the point of charge. And he was awarded £25,000 for misuse of private information, distress, and embarrassment caused by the article.
Cersei and Associated Newspapers is a fairly similar case to ZXC, but is more recent. It involved an individual who'd been arrested and held in connection with the Manchester arena bombing. He'd been arrested because he'd received a phone call from the suicide bomber, but it transpired that the call was about something entirely unrelated, and he didn't know the bomber at all. The individual was therefore released without charge a few days later. But on the day of his arrest, the defendant published an article online which included his name, address, nationality, and occupation, and didn't amend or update the article to make it clear that he'd been released without charge. The article stayed online for 9 months before it was taken down, after the claimant had instructed lawyers. And the claimant was awarded damages of £83,000. Of this, £50,000 was general damage to award for the wrongful disclosure and distress, as well as aggravated damages, amongst other things, due to the defendant's conduct. The remaining £33,000 was called special damages, which was basically for financial loss that the claimant had suffered. One of the most useful cases in responding to data breach claims is the TLT and Home Office case. And this is an example of an accidental data breach, but one that could have had serious consequences. 6 asylum seekers brought claims against the Home Office for misuse of private information and the breach of the Data Protection Act. Personal data about them, including their name, ages, and immigration status, had been inadvertently published on the Home Office website. And was accessed a number of times. It was downloaded, it was accessed abroad before taken down 13 days later. And these are people who genuinely had a vulnerable status. Some of them were genuinely in fear of their lives. And they were awarded damages of between £2,000 and £12,500 each. This is a really helpful case when you're responding to a data breach claim. Think about the sort of breaches that normally occur on a day-to-day basis in HE institutions. It's going to be someone's contact details or their course results. It's hardly on the same scale as being in fear of your life, is it? I do suspect, however, if TLT was decided now, I think the damages would be probably quite a bit higher, but even so, it is a useful benchmark. By way of probably the most extreme example, you'll no doubt all have heard about the Sickliffe Richard case, and hopefully just the extreme nature of this means that it won't really have hopefully any bearing on the sort of issues that you might be involved in. Sickliffe had sued the BBC for breach of privacy and data protection rights following the BBC's high-profile and extensive coverage of a police raid on his home in connection with an allegation of historic sexual abuse. It was subsequently announced that no charges will be brought against him. He was awarded damages of £210,000, £190,000 of which was said to be attributable to the breach itself and reflected, amongst other things, the reputational damage suffered as a result of the breach. And the additional £20,000 was to reflect the BBC's decision to submit its coverage for an award. The court acknowledged that the damages in this case were exceptionally high and very specific to the facts of the case. It is, however, helpful to contrast these with a few lower value awards. Sarah.
So the next case on our slide is ST and another against L Primary School. In that case, a school had sent a letter to parents in a year group that was designed to reassure them following some behavioural incidents involving a disabled pupil. The letter included the pupil's name, her year group, and her disability, and referred to the fact that her behaviour could be regarded as disturbing and could lead to safety concerns. The pupil's mother alleged that the letter amounted to a breach of the Data Protection Act, breach of the Human Rights Act, and misuse of private information. The High Court held that both the pupil and her mother had a reasonable expectation of privacy about the information contained in the letter, and disclosure of it could not be justified. The court awarded £1,500 to the pupil, as there was limited evidence of the direct impact of the letter on her, and £3,000 to the mother, which the court considered properly reflected the distress that she has. The next case we have is JQL and NTP. This case involved an uncle who was embroiled in a family feud, and he published a post on Facebook about his niece, which referred to the fact that she had mental health difficulties, had self-harmed, and had been receiving treatment. The post was on Facebook for about 3 hours before it was taken down, but only after about 20 to 35 people outside of the family had seen it. The court awarded the claimant damages of £15,000, which included significant aggravated damages. It's interesting to look at the awards in these cases, and although they're not all directly comparable, I think it's probably fair to say that for more run-of-the-mill, one-off accidental breaches, the damages are unlikely to be very high. However, when you consider that a lot of the reported cases involve serious high-profile breaches, we often find that half the battle when defending claims of these kind is managing the claimant's expectations. In the HE context, the kind of things we tend to see are one-off breaches, either accidental or as a result of malicious activity, and involve rather generic personal data of students or employees, such as names and addresses. In these kinds of circumstances, the damages tend to be relatively low, but the cost of dealing with them can quickly become disproportionate.
There is one important caveat to this, though, which we'll call the floodgates issue. Now, of course, if your breach involves just one individual, perhaps because an email was inadvertently sent to the wrong person, then dealing with the claim and resolving it may, I'll say may, be relatively straightforward. However, if the claim arises from an incident when many people have been affected, for example, because your database has been hacked or compromised, you may want to take a very different approach. Of course, if a breach does potentially affect many thousands of individuals, then statistically it's unlikely they'll want to bring a claim, as we've discussed, although that will of course depend on how serious the breach is. And as we mentioned earlier, in the Morrisons case, there was 120,000 employees, but in the reported decision, only 9,000 of them brought a claim. However, if an individual claim is not worth very much, for the sake of arguments, let's say £2,000, If there are potentially hundreds or thousands, then suddenly the potential liability can start to snowball, and that's before you even start factoring in your own costs, management time, and of course the claimant's costs. Without wanting to be too doom and gloom, if one or two claims come in after data breach, then it's always possible that more will follow. Claimant solicitor firms may even only bring one or two claims first to see how they pan out. If they settle, for example, they may potentially tout for more claimants by advertising the fact that they've already obtained settlements for claims arising from that breach. The first one or two claims can therefore create a precedent or an expectation on the part of the claimants and their solicitors as to how you'll deal with the remainder. So it's really important to bear this in mind from the outset, and can of course be an important factor in negotiating confidentiality clauses. Just on that, there's been a lot of negative focus on NDAs, particularly within sort of Weinstein type scenarios. But I think this is misdirected when it comes to data breaches. It's not trying to cover up ongoing issues. I don't think I've ever had a HE client who said they want a data incident covering up. They want to get on with it and deal with it, with the regulators properly informed, lessons are learned, and move forward. Confidentiality provisions can't stop somebody from going to a regulator or a public authority with a complaint, but protecting commercial interests in settling a claim and reducing the risks of further claims being brought is a different matter, and I can't see there's anything wrong with that. There may be some cases where it's worth paying over the odds just to settle a handful of claims where many others are affected.
Next slide, please. Okay, so the other big financial liability to bear in mind when it comes to data breaches is fines by the ICO, which is just one of the suite of enforcement measures that they can implement. Now, as you may know, under the old pre-GDPR regime, the maximum fine the ICO could impose was £500,000. However, this changed with the introduction of GDPR, and the higher maximum is now the higher of £17.5 million, or 4% of a company's global turnover for the preceding financial year. We've got a few examples of fines on this slide that have been levied for breach of the GDPR. So the first one is Doorstep Dispensary Limited, and this was actually the first fine that was imposed after the introduction of GDPR. This was a pharmacy business that provided medicines to customers and care homes. And it transpired that the company had left some 500,000 documents in unlocked containers at the back of its premises. These documents were dated between June 2016 and 2018, and included information such as names, addresses, dates of birth, NHS numbers, medical information, prescriptions belonging to an unknown number of customers. As well as issuing an enforcement notice, the ICO fined the company £275,000 for failing to ensure the security of this special category data. So another example we have is British Airways. So between June and September 2018, the company suffered a malicious cyber attack, excuse me, which allowed the hacker to gain access to the company's network and attempt to obtain cardholder data from the company's website. Over 400,000 customers' personal data was left exposed to the attack. BA promptly notified the ICO of the attack once it became aware of it and fully cooperated with the ICO investigation. The ICO found that BA failed to process the personal data of its customers in a manner that ensured appropriate security of the data, and weaknesses in BA's IT security should have been identified and remedied, which would have prevented the attack. Taking into account the impact of the COVID-19 pandemic and other mitigating factors, the ICO fined BA £20 million. Another high-profile incident was that of Marriott International. Marriott had acquired a company called Starwood Hotels and Resorts Worldwide back in 2016. It transpired that Starwood's reservation database had been hacked in 2014, enabling the attacker access to encrypted and unencrypted data, which included guests' names, date of birth, address, contact details, passport numbers, and card details. Marriott estimated that 339 million guest records were affected, of which just over 30 million were EEA records, and 7 million of those were associated with the UK. Marriott promptly notified the ICO of the breach when it became aware of it and updated its system. But taking into account a range of mitigating factors, again including COVID, the ICO fined Marriott £18.4 million. Our final example is Ticketmaster. Ticketmaster on one of its online payment pages. The resultant data breach included customer names, payment card numbers, expiry dates, and CVV numbers. Now here, Ticketmaster were unable to provide the ICO with a breakdown of the individuals affected between the relevant dates, but 9.4 million EEA data subjects were notified as having been potentially affected, of whom 1.5 million were in the UK. Furthermore, Barclays Bank had advised that 60,000 individual card details had been compromised, and Monzo Bank had advised that around 6,000 cards had to be replaced as a result. Ticketmaster themselves received 997 complaints alleging financial loss or emotional distress. The ICO found that Ticketmaster failed to put in place appropriate security measures to prevent a cyber attack on the chatbot and failed to identify the source of suggestive fraudulent activity in a timely manner. And as you can see, it fined Ticketmaster £1.25 million. Now, to offer some reassurance, not all matters that are reported to the ICO end up with massive fines. And I think it's fair to say that these cases are very much the exception. We quite often find that the ICO does not take any significant action with smaller breaches, especially where the organisation can show that it's taken all the right steps, such as having the right policies in place, having trained its staff properly, and having properly considered and implemented any lessons learned. So next slide, please.
Well, I hope that wasn't all too doom-mongery, and hope that gives you some food for thought. As Sarah said, the cases that get reported tend, on the whole, to be the bigger ones, and most of the ones that are run of the mill, and certainly the ones that we deal with, usually don't tend to be anything like that size. But it's still important to deal with them in an appropriate and fair manner to make sure you've dealt with all your regulatory obligations, and also just from a PR perspective, just to be seen to close them down and to avoid any further issues arising out of it. And unfortunately, with the best will in the world, data breaches can and do happen, and quite often they're just down to human error. The important thing is to make sure you've got all the appropriate measures in place, and know what to do if a data breach does arise. So just to recap on what we discussed today then, if a data breach does arise, don't panic. Don't be pressured into giving any detailed comments and statements at an early stage unless you're feeling very confident in them. Ensure you have a coordinated approach and that everyone in the institution knows what they're doing. Think who you need to notify. This might be the police, it might be regulators and insurers, as well as those affected and other stakeholders. The usual type of claims that are brought for data breaches are for breach of data protection, misuse of private information, and breach of privacy or breach of confidence. Employers can, but not always, be vicariously liable for acts of their employees in these kinds of cases. Despite the high-profile reported cases, these kind of claims are usually not worth relatively huge amounts. What we're really looking for, and this is a bit of a pet subject of mine and Sarah's, is trying to put a value on what if somebody's name and address has been leaked. I mean, to my mind, it's almost worth nothing. We're awaiting a decent court decision on this. I was actually quite hoping that the Morrisons decision would have gone the other way, and that it would have found Morrisons vicariously liable, but the claims were essentially almost worth nothing. And that would have batted back this industry of opportunistic claims. But they can still be costly and time consuming to deal with. And bearing in mind, you need to be mindful of the risk of opening the floodgates. Also bear in mind that the ICO can impose fines on organisations in these circumstances, and those are of course separate from any civil action that someone might want to pursue. And those fines can be, you can convince the ICO to reduce them potentially if you can show them that you've done all the right things, that you had the right policies in place, that you followed up in the appropriate way. So it's important to know that the steps you take now to make sure that you've got all the policies and procedures and training are suitable and up to date, and you know what to do if a breach arises. So thanks for listening today. I hope that's been helpful. I think the way these talks have gone online has been a bit more like Netflix, because we're at 47 minutes, which means the talk's probably about 45. So it doesn't mean that we're absolutely committed to doing the full hour on it, but we've still got some time for any questions. I'm just looking at the Q&A. I don't think any have been submitted. So if anyone does want to try and pop some in now, we'll give you a minute to think about it. But otherwise, I think that's broadly all that we wanted to say for now. And there we are. We've had a question with respect to alumni. Does the exhaustion of students' business relationship have an impact on data protection issues? Could you, whoever the questioner was on that, could you just expand a bit more about what you mean on the exhaustion of the students' business relationship? I mean, as I said earlier, I think the position with alumni is quite interesting, and certainly data breaches for universities that we've seen, as I mentioned in the talk, you do get quite a lot. I think you get quite a lot of loyalty with your students, and it doesn't tend to result in huge amounts of claims that I have seen so far for innocuous breaches. Another question in, how would you suggest we approach claims for compensation rather than seeking to take the university through the courts? Will existing judgments remain a good guide? Yeah, I mean, it is almost always the case that it's going to be, even if there is a defence to it, it's almost always the case that reaching some sort of sensible resolution is commercially the most sensible thing to do, because if you go all the way to trial, your costs are going to be assessed. They'll be reduced. Even if you won, a rule of thumb might say you might get about 2/3 of your costs back. Well, the third of the cost that you'll spend on that is pretty likely to be significantly more than the costs for settling it. So unfortunately, it usually is the case that it's just worth getting it settled. And yeah, I think existing judgments do remain a good guide. So I mean, the one that we always, we try to avoid going into quoting cases in the correspondence, but if you do need to, the TLT one is one of the most helpful ones. It's a few years old now, and as I said, I think it'll probably be decided differently if it was brought in now. But you're fearful of your life, you've got a death warrant against your head in a foreign country, and you're living under a pseudonym. Having that information broadcast is obviously really serious, whereas having your name and what your result when your second year was isn't really all that serious. Sarah, is there any question that you wanted to pick up there?
I can see a question. What other types of enforcement action can or will the ICO typically impose instead of a fine? So I think I said in the presentation that obviously the fine is only one of a number of measures that they can take. And I know that they can impose other things as well, or instead of a fine. They can basically, they have a power of inspection, so they can inspect the institution or appoint a third party or require you to appoint a third party to inspect the institution. They can issue what are called information notices that require you to take or refrain from taking, that require you to provide them with information, or enforcement notices that require you to take or refrain from taking particular steps or actions. So there's quite a few things that they can do, but the fines are typically what draw the most public attention.
Thank you. One question that went in the chat box, which is a good one, is there a court decision actually pending on the value of names and addresses? Not that I'm aware of, unfortunately, and it's going to need to be a big one, which is why I said I was rather hoping that the Morrisons decision would have gone the other way, because there was a whole array of information there. I'm sort of semi-joking when I talk about the what somebody earns, is how serious is it? But there are so many. The majority of cases that we see are for fairly innocuous information coming out, or it only goes to a very limited audience. We really do need a decision on the value of these. Somebody else also, isn't there a precedent for claims for distress inconvenience? So no need to show damage. Yes, that is you don't need to show financial damage, but the trouble is it's assessing the value of that distress and inconvenience that's been caused. So how upset is somebody? I mean, it kind of depends upon the individual person as to what the impact is. That's obviously the whole point of damages, is to compensate somebody for the loss that they've suffered. So some individuals may suffer more by loss of that information, such as the people in TLT. Their address being disclosed is going to be far more distressing than if my address was accidentally put on this forum. Who cares? But there would still potentially be a data breach if my name and address was put on the forum. How much is it worth? I mean, I just personally couldn't be bothered doing anything about it. So, but if I did bring a claim, there would be some value added, I think. So, you know, is it worth 50 quid? I don't know. It's that we have no proper guidance on the level of these claims. And ideally, if the court would make a decision on that sort of thing, when we get a case like Morrisons coming back through again, and ideally it will say these claims should never really have been brought in the first place, so they don't get any costs, and then that will hopefully bring us back to normal. It's just one of those pieces of legislation that seems to have caught the public imagination, and now everyone thinks that they've got a claim because they've heard of data protection. And you know, whenever you phone up anybody to ask anything about any account you've got or something, and they won't tell you for data protection reasons, even though it's you that's phoning. It's just one of those misunderstood things that people think they're worth a fortune, because the cases we talked about today, the Cliff Richard case, you know, all of that sort of stuff, people are aware of them. The phone hacking cases have been in the press for years, and you know, the fact that everyone knows where David Tennant went on holiday or something, well, I mean, that's probably of greater significance than if anyone knew where I went on holiday. Sarah, have you spotted any other questions you want to pick up on there?
I can see there's a question. Do you consider that research data subjects are at a higher risk to HE than breach? Well, subject to any thoughts you have, Ben. I'd have thought, I guess it depends on the type of data you're holding about the data subject. Potentially, I guess, you may be holding quite sensitive data about research data subjects. And so again, that could pose a higher risk, because as we know, the more sensitive the data, you know, the more serious the consequences can be if there's a breach.
Yeah, absolutely. But the very nature of research data subjects suggests that they probably have been selected. So that in itself might suggest that they are higher risk. And obviously, you know, there are different categories of data. Your name and address is less important than your medical data. So if it's something within a medical faculty relating to someone's contagious condition, anything that's particularly personal about them is going to be worth more, basically, in terms of putting pound notes on it. Got a question here. What other measures can you put in place to ensure that suppliers that you are contracted to have an adequate provision for protecting a higher education institution's data other than what is covered in terms and conditions and cyber liability insurance? I mean, obviously, the contract is the thing to try and ensure that you've got it covered off. That, you know, in real terms, what is it that the information that you're supplying them with? If you don't give them the information in the first place, then it becomes harder for them to do anything wrong with it. I mean, I think, as you say, you know, have clear terms and conditions, setting out what their obligations are, which is critical. Make sure you do have the insurance. Make sure you have made them aware of your policies and requirements. The issue is that you probably can't. One issue is that you probably can't pass on any liability for a fine, because that's going to almost certainly be for the institution as a sort of a penal sanction. You could include some provision in there for how you will divvy up any liability on a civil claim if anyone was to sue on it. But no, it probably does come down to doing the best with the terms and conditions, and then also thinking for a practical level about the information that is being provided. Just trying to have a quick scan through. So, is there any?
So I'm not sure if you've answered this one already, but there's a question here about, are you finding that cases are referred to you pre-action? And I can certainly say yes. things are absolutely being referred to as pre-action. I think the majority of stuff that does come across our desk, these kind of claims, tends to be pre-action. You know, a letter of claim will land on someone's desk at the university from a law firm. It's usually very long, usually just quotes endless reams of the Data Protection Act, and looks big and long and scary. And we tend to get involved at that stage then to help position the university and then take that forward, hopefully get it sorted quickly.
Yeah, absolutely. And the pre-action stage does tend to take some time. I mean, certainly in these cases, I'm finding on the whole that the claimant solicitors don't tend to rush in that quickly to actually issue a claim. Indeed, one that we're working on at the moment, we've been in pre-action correspondence and negotiation with them for about 4 years, I think. It's on and off, it's not constant, but they don't tend to be in that much of a hurry. But equally, they don't seem that much of a hurry to get it settled either. So it's quite interesting. I think a lot of them probably lose a bit of momentum if their package of trying to pull claimants together doesn't seem to quite get off the ground. I mean, they operate in similar way to sort of the PPI and the emissions cases. You'll see them advertised. I think they probably get more traction with those sorts of cases on the whole than they do with data breaches. But obviously, somebody did quite a good job on the Morrisons one in terms of trying to attract potential claimants to that. But yeah, absolutely. You know, the other side will come back with some ludicrous explanation. Quite often, they don't tell you what they think the damages are worth, and then when they do come up with a figure, it's one of those occasions where it is helpful to refer to case law where you can to try and bat them back down again to say no. You've got to obviously pick and choose your examples quite carefully. I'm conscious that we're getting up to 12 o'clock. I'm not sure if we've got time to cover up any more questions, but we'll certainly note those and aim to follow up as appropriate, maybe in the thing that goes out towards the end of the week. I see there's been a few just recently coming in on the Blackboard issue, so maybe if we just do a short commentary on that when we send out our the slides and the talk later, and that will hopefully be helpful for everyone. But we've gone 12, so I'll say thank you very much for everyone for attending. Hope that was all right, and we'll see you shortly. Thank you.